side of oops.
1 second. Ma'am, I can confirm that we have a quorum. We have present in this meeting Honorable Geronima Augustino, the chairperson of the DG and HR Mozambique. Honorable Darren Bergman, vice chairperson of the DH and HR South Africa. We also have yourself, ma'am, the acting chairperson of the HSDB and SP from Malawi. We have Honorable Stridum Panza, the vice chairperson of the same committee. He's from Eswatini. We also have Honorable Pete Ramakwai, chairperson of the GEWA and YED from Lesotho. And we have Honorable Masi Gaoloma Marianne Jean, vice chairperson of the GEWA and YED Madagascar. We also have with us Honorable Maria Do Camo Do Namasito Proxy for Honorable Ruth Mendez, Vice Chairperson of TIFI Angola. Absent with apology, Honorable Acting Chairperson is Honorable Annelyn Debele of the TFI Chairperson from Zimbabwe, Honorable Andre Leon Tumba, the Chairperson of FAN-R DRC, who is also the Chairperson of this committee. And we have Honorable Malefane, Vice Chairperson of FAN-R Lesotho, and Honorable Bilambangu, Chairperson of RWPC DRC. And the Vice Chairperson of the RWPC Tanzania is still not constituted.
Thank you so much, Mrs. Ore. Honourable members, we go to agenda number 2, item number 2 on the agenda, consideration and adoption of the agenda. Honourable members, the draft agenda for the meeting was circulated to all members. Are there any proposal to amend the draft agenda? Honourable members, I haven't seen any hand, so it means we can go ahead to adopt the agenda. Honourable members, who moves for the adoption of the agenda? Hello, can you hear me, honourable members? Hello.
I'll propose.
Right, I can see South Africa. Honourable member from South Africa. You can.
Thank you. I will rise to adopt the agenda.
Any second, honourable members? Honourable Nana. you have put down your hand. Yes. Honourable Poku. Honourable Poku, we are waiting for you.
Chair, Honourable Poku may be excused. He's not a substantive member of the committee.
Okay.
If honourable members assist with the adoption, who are either vice chairperson or chairpersons of the standing committees. Thank you.
Any honourable member to second the adoption of the agenda? Okay, I can see honourable member from Madagascar. I recognize you. Madagascar, honorable member. My hand is gone again. Are we having challenges with IT? Honorable members, we need a seconder to adopt the agenda. Madam SG.
Chair, it is online.
You're breaking.
Honorable Chair,
Yes.
I'm beginning to doubt if the members are really online, since by now they could have responded.
Yes. Your
Could any
guidance.
other, Honorable Mohadi, I saw now Mohadi online. Could Honorable Mohadi kindly assist with the adoption of the agenda?
She's currently not in SG. It looks like there could be network problems because Honorable Geronima from Mozambique was in. She's temporarily out. Honorable Mohad was in, temporarily out.
Could Honorable Maria Nascimento assist us with the adoption of the agenda? Honorable Strider Mpanza is second.
Sim,
He's
sim,
on.
sim. Chamou pelo meu nome.
Angola?
Sim, chamou pelo meu nome.
Thank you, thank you.
Thank you so much, Angola, for seconding the motion to adopt the agenda. The agenda is accordingly adopted. We now, honourable members, we now go to item number 3. I'm going to present my welcome remarks on behalf of our chairperson who sent an apology. Honourable members of the Regional Parliamentary Model Law Oversight Committee, the Secretary General, Ms. Boemo Sekoma, Secretariat staff, resource persons, interpreters. It is indeed an honor to welcome you to the meeting of the Regional Parliamentary Model Laws Oversight Committee. This marks our second meeting as a committee since. I thought I should begin by highlighting that the Regional Parliamentary Model Laws Oversight Committee is a young organ having been established in June 2018. The Regional Parliamentary Model Laws Committee of Oversight Committee was established by the Plenary Assembly with the primary objective of monitoring and evaluating progress by member states in domesticating the SADC model laws and implementing related laws and policies. This obligation levies on us the onerous task of convening regularly to deliberate and advise SADC PF on the progress member states are making in fulfilling the objectives of the various model laws. The Regional Parliamentary Model Laws Oversight Committee must also track implementation by SADC member states. To date, it can be said that in tracking implementation, there has been slow implementation, in some instances, non-implementation of regional and international commitments, and this is unsettling as it stalls the regional integration agenda. Our role as parliamentary committee tasked with monitoring implementation can therefore not be overemphasized. For instance, one of the areas where SADC-PF has developed a model law is eradication of child marriages. I anticipate that we will gain a lot of knowledge from the presentation to be delivered by Ms. Eva Jala on this model law on the eradication of child marriages. Likewise, with the presentation from Dr. Dingake, which will draw examples from the model laws on HIV, AIDS, and elections. I must also highlight that the gender-based violence model law is also currently under development and have reached a stage where we will soon see its fruition. That being said, honorable members and colleagues, from the above examples, it is indisputable that our committee has a lot of work to do to monitor progress of implementation. Until the model laws are domesticated and implemented, they have no substantial value. That being said, as we work under the theme, augmenting the enhanced execution of regional obligations by national parliaments, we must fully be aware of what lies ahead. In conclusion, allow me to extend our appreciation to the Secretariat led by the Secretary General, Ms. Boemo Sekoma, for always doing their best to facilitate the work of this committee. It is now my singular honor to declare the meeting of Regional Parliamentary Model Laws Oversight Committee officially opened. I thank you, honorable members. Honorable members, we now go to our item number 4, where we are going to have Dr. Dinkanke with a presentation. Over to you, Doc.
If I may, Honorable Chair, with your permission, we would like to advise honorable members that when they take the floor, they should kindly switch on their videos. This meeting is being streamed live on social media and will be recorded for later broadcast on DSTV channel 408. I thank you, Honorable Chair, for the decorum that should ensue. Thank you.
Thank you so much, Madam FT.
Honorable Justice Dingake, is he online?
Yes.
Am I clear?
Yes, Honorable.
Yes.
Yes, Doc.
Can I proceed?
You can go ahead, Doc.
Thank you, Director of Proceedings, for today's event. Acting Chairperson, honorable members, Secretary General of SADC PF, colleagues and friends from the SADC PF staff, I start off by expressing gratitude for invitation for me to share with you my thoughts on a topic which you assigned me, which is to tackle the question of the role of parliamentarians in domestication of model laws. I will be doing so with a selected focus on the SADC modern law on HIV and AIDS and on elections, just to demonstrate what I'll be talking about. I think it is convenient to start this particular topic by asking a question. It is a fundamental question that strikes at the very heart of the current engagement. And the question, honorable members, is this. After so many years of adopting model laws, particularly the HIV one, which has been around for decades, and followed by the subsequent one on elections and child marriages, the question that arises is, where are we now? Where are we now? And I found it quite gratifying, actually, that to answer that question, the acting chairperson, in her eloquent remarks, actually hit the nail on the head. And I can do no better than her in simply highlighting what she said for your noting. And that, in my mind, encapsulates the situational analysis that we find ourselves in. She says that there is slow implementation in some cases. In others, she said there is none implementation. And I borrow the words that she used and adopt them as my own because I found them poignant. She said this state of affairs is unsettling, unquote, as it slows the regional integration agenda. I hope I do not misrepresent the acting chairperson, but I think she was spot on this. And she concluded again with a poignant remark. And again, I quote her. She says, unless modern laws are domesticated and implemented, there will be no substantial value, close quote. If it were for me, Madam Secretary General, on this note, I would say that this meeting must officially close because the message has been relayed. But the question, the subsequent question that arises, conveniently anchored upon the remarks of the acting chairperson, is what are the real challenges? What are the real challenges? And as I see it, the real challenge around the domestication and eventual implementation of modern laws arises from the fact that SADC PF is still in a state of evolution and moving towards a supranational legislative body with full binding legislative powers, which hopefully in the course of time will come to eventuate. But what I know for a fact, on account of my privileged position having worked with SADC PF from the moment of the conception of the HIV model law, is that the SADC parliamentarians fully embrace the work of SADC PF and are fully committed to their mandate as human rights actors and their mandate to deepen democracy in their areas. I can say that with some certainty. I am not sure whether I can say the same of the executive. I think if the executive were in the same page as the parliamentarians, perhaps, Madam Acting Chairperson, will be speaking of some better progress around the implementation of modern laws. If that is a gap, Madam Chairperson and Honorable Secretary General, it therefore behooves us to reflect on how best we can bring closer the executive, because both the executive and the legislature must engage in a constitutional dialogue and to pull in the same direction. Over the years, judged by the quality of its interventions and measured against international best practice, SADC-PF has established itself as a progressive institution that has fully embraced human rights-centered approach in everything they do. They have embraced the rule of law, and it is clear in their records, it is well documented. And the failure, therefore, or reluctance to embrace the modern laws may suggest that the institution perhaps, and I say perhaps, Madam SG, may perhaps be living ahead of its time. The contextual and political environment under which it operates is uneven, characterized by advances and retreats in democratization, including in some instances regression. Negotiating these tensions and twists, Madam Chairperson and Secretary General, require some diplomacy, I guess more so when it comes to what the Secretary General has to do. And it requires patience from all of us, and requires MPs to rededicate themselves to the work of the SADC-PF. It requires, of course, Madam Acting Chairperson, independent parliaments. It requires a continuing constitutional dialogue between the legislature and the executive. It used to be thought in the yesteryear that human rights are not the function of parliaments or even the executive. That view is fast losing its shine, because it is accepted that parliamentarians are human rights actors as they embody the will of the people who send them to parliament. This position of the role of parliamentarians in advancing democracy, in advancing good laws for the good order of their countries, is recognized internationally by the United Nations General Assembly, United Nations Human Rights Council, the Interparliamentary Union, the Commonwealth Parliamentary Association. The primary duty of any parliament is to pass laws that promote the welfare of the people. And parliament's law-making functions means that they are well placed to ensure that effective measures are taken to ensure that modern laws that we pass, that we embrace, because we think they represent the values, they represent where we want to go, and that in the interest of the welfare of the people, must be domesticated, Madam Acting Chairperson. Because if that is not done, we are slowing the integration process of our region. So we need to recommit as parliamentarians as to what we should do to domesticate these laws. And Madam Chairperson, I am aware of the contextual legal constraints around this agenda, which I wish to highlight. Today, as we gather to consider the role of parliamentarians in domesticating modern laws, we need to pay heed, of course, always, increasingly, to our own legal systems that shapes and constrains what we can do. We need to start there, Madam Acting Chairperson and Secretary General. What is it that is constraining our work? The legal system, at least of the majority of SADC states, is founded on what we call legal dualism. And legal dualism, basically anchored on the sovereignty of states, says that anything outside the nation state to become law in a particular country must be domesticated and transformed. And there are certain procedures for transforming something that comes out of the nation state. And we also know that the ratification of treaties or bringing on board international treaties, declarations and protocols, including soft law, which SADC model law may be taken to be, arguably, requires the involvement of the executive. So the legal system of most SADC countries is founded on legal dualism. And dual legal monism, dual legal pluralism goes hand in hand with monist states, in which international law, once ratified, automatically may become part of national law. But most of the SADC states are not monist, although some may have some monist features. So model law, as I suggest, is some form of soft law, I would want to argue. And this much actually has been made patently clear by the Secretary General, the current Secretary General of SADC PF, in the executive summary, I think, of the model law on HIV. The document actually goes to a great length to characterize what model laws are. And today I want to actually re-emphasize what they are by saying that model laws, the nature and character of model laws, arguably soft law, is mainly inspirational, is mainly to be used as a guide. There is no requirement on Parliament to actually simply take as is those model laws and make them the laws in Zimbabwe, in Malawi, in Botswana, in South Africa, in Namibia. What is required is that for MPs to read, get the inspiration, borrow certain things which are relevant at a particular developmental phase of their country. So it's some kind of reference point. But since we are the ones who adopted these laws, I think it makes sense that we must now begin, Madam Secretary General, to track progress, to ask ourselves, what is it that we have done? And those countries that have made minimal progress actually ought to be celebrated and used to inspire other countries to advance from the point where they are. As a resource, we need to view model laws like that. Model laws are flexible and allow states to make adjustments to the text of the model to accommodate national requirements that vary from country to country. And because model laws are essentially legislative guides, strict uniformity is not necessary, it is not required. It is precisely this flexibility that makes model laws user-friendly legislative tools. However, despite the flexible nature of model laws, states are often encouraged to make few changes as possible when incorporating model law into their legal systems. There are various reasons why countries use model laws as a basis of the development of domestic legislation. Some countries may adopt the model law because the legal community and the policymakers in that country regard the model law as representative of the values they embrace. And the values that are found in all your model laws as SADC PF are actually consistent with what governments have ratified in international treaties around issues of HIV and elections. So it's nothing strange, it's nothing inconsistent, it's nothing incompatible, because already states have committed to that. What it then requires is parliamentarians to say in their own nation states, to debate these issues with the aim of adapting the national laws to be part of local laws in order to best advance the interests of their own communities, their own voters, the interests of the welfare of their people. It is obvious to me that the drafting style of model laws may differ with those of member states. It is obvious every member state drafting division at the Attorney General's chambers may have its own unique drafting style, its own unique format. But that is not the case. We cannot be slaves to form. We cannot be slaves to form. We would rather choose to be slaves to substance. And because the substance of these model laws is what we have already committed to, we should be able to negotiate the situation where the form is different, to be able, acting chairperson, as you said, to implement in order to advance the integration agenda of SADC. Often modern laws are resisted by lawyers and policymakers simply on the basis of form. We need to overcome this barrier and hindrance in order to make progress. And it is also important for states to study carefully the reasons why a model law adopts a particular formulation and the rationale for policy choices it makes. It seems plain to me that model laws are the best tools for SADC-PF to use in the current developmental phase to guide parliamentarians in the region in certain selected areas of legislation, because SADC-PF has no supranational legislative powers like other regional bodies. So it makes sense to adopt soft law, but place its faith on the commitment of its members who passed it to then domesticate it at their respective nation states. But I think there must be some tracking system, some monitoring system, some evaluation system, some follow-up system, some engagement with the executive in order to advance in this front. Through its model law function, SADC-PF can set normative standards relating to pertinent human rights issues. It has done so with respect to HIV and the law. It has done so with respect to child marriage and elections. Even in the absence of legislative powers, one wonders whether there is an argument that can be made that perhaps in the long term, such model laws may, even in the absence of domestication, be considered persuasive even in the courts. I am certain that certain progressive jurists around our region in the course of time will begin to bring on board this soft law as part of international human rights regimen, simply because it echoes that which is already there in international legal regime. So I think at one stage, SADC-PF must consider engaging the judges who can even move faster in incorporating this in the national jurisprudence. And in that way, you will find that the three organs of the state, being the executive, the judiciary, and the legislature, pull in one direction towards the advancement of human rights and deepening democracy. If that day comes, this region will be a beautiful place to stay, and I hope MPs can make it happen. So the time perhaps has come, Madam Secretary General and honorable MPs, to intensify efforts towards supranational legislative body for the region and to jettison the yesteryear notions of sovereignty upon which most member states design their foreign policy. In this current evolving state, without any legislative powers by SADC-PF, its capacity to contribute to region's human rights agenda is weak and hindered. This is not a novel observation. Indeed, the SADC-PF has already set itself very high standards, and if we cooperate with the leadership, we can make advances that are historical. I turn now, if time is still permits. I don't know, Madam Chair, do I still have time? I want to, if I do, I want to focus quickly on selected examples from the HIV model law. The HIV model law guarantees respect for human rights principles, rejects coercive approaches, addresses root causes of vulnerability to infection, and ensures protection of members of vulnerable groups, such as the key members of key populations. And this is because, again, I emphasize, according to SADC-PF, human rights-based approaches have been proven to work in addressing pandemics or epidemics. Many SADC states are already party to treaties around HIV. And it is important, therefore, to live literally those promises. Take one example of obligations engendered by model law on HIV and AIDS. The state is obliged to sensitize communities about the dangers of harmful cultural practices that contribute to HIV transmission, such as early child marriages, forced marriages, female genital mutilation, window inheritance. We ask the question, how far are we? Again, the answer has been given by the acting chairperson in her remarks. Progress is not satisfactory, it's uneven. In other countries, it hasn't even started. So we need to make sure that we do something. I take the second example of the right to access to healthcare. People living with HIV have the right to healthcare services, leaving no one behind, including provision of antiretroviral drugs. But where are we now? Are members of the key populations included? Do they have access to public health services, or are they legal impediments on doing so? And if they are, when are we going to address those legal impediments? Why are parliaments unable to accept the reality that in prisons there is consensual and non-consensual sex in prisons, and that HIV is spreading in prisons, and that it is in the interest of public health that certain measures, legislative measures, inspired by the SADC model law of which they are adopted to be effected? So those are the questions that, on account of time, I pose in order to illustrate the point. Then we come to the elections model law. Again, another document, brilliant document by SADC PF. If we can live up to this, even a fraction, even a 1/3 of what we say and we have written and documented, have agreed, we subscribe to, we can pat ourselves on the back that we have made progress. In his foreword to the SADC model law on elections, President Wavell Ramkalawan of Seychelles observed and echoed the sentiments similar and consistent to the sentiments that Madam Acting Chairperson, you articulated. And he said that although the development of various election instruments within SADC is a positive step, the majority are not legally binding, posing challenges of effective domestication. And he also called for the integrity of SADC electoral processes. And in doing so, he was speaking to so many aspects of the electoral processes in the region, which we have documented in our model law. It includes, among other things, the independence of electoral management bodies. That remains a big issue in our region. In some countries, there are concerns that their independence is not sufficient or is compromised, or that they are an appendage of the executive. Those allegations cannot be dismissed as idle, having regard to recent pronouncements by the Constitutional Court of Malawi and the Supreme Court of Malawi that impugned the manner in which the election that was quashed was conducted. Yet our reference point, the election model laws that we adopted, if we were to follow through, we would not be having these complaints, and we will not be having the judges having to determine whether or not an election was conducted independently, fairly, freely, and is consistent with the will of the people. The other second example in the SADC model laws is effecting a level playing field. It calls for funding of political parties. I know that South Africa recently either upgraded or dealt with this matter, including regulation of private funding of political parties. That is a big issue, because why is the regulation of private funding of political parties a big issue? It is a big issue because if it is not regulated, private entities will hijack the democratic dispensation, and their views will end up be the ones directing public policy, will end up running the countries of which we are MPs. And the reason why we need to regulate private funding, and to me it's an urgent matter, is because it will subvert the will of the people. What the people will want will no longer matter. What will matter is who has funded which party. Yet our own model law, SADC model law, has clearly articulated what needs to be done. So I conclude, Madam Chairperson, and I hope I did not take much of your time in saying again that I can do no better than to emphasize that we have a role as MPs to adopt these model laws, to adjust, to revise them, to take certain sections, not entirely the whole model law, but if we do take the whole model law, speaking for myself, I will be very excited and happy because it has all the best that we need. But we can go at our own pace, according to the circumstances of our country, and make progress in this field. Thank you, Madam Chairperson, for your kind attention. Thank you, Madam Chairperson. Hello?
Thank you, Judge. I'm sure the chair will be responding.
Did I lose you at any stage? Maybe I lost you many hours ago.
No. We heard
okay.
you.
Okay.
Maybe.
Hello?
Ms. Hove? Oh.
It's the chair, ma'am.
Hello? Thank you so much, Dr. Dikange, for such an edifying presentation. Now, honored members, are there any questions or comments on Dr. Dikange's presentation? I see hands. Honored members, I see no hands being raised. Once again, thank you very much, Dr. Dikange, for such an edifying presentation. Honored members.
Thank you, Chair. I appreciate.
Welcome. Honored members, we now move to the next item, which is an overview on the mandate of the Regional Parliamentary Model Laws Oversight Committee and priority activities of the committee for 2020-2021. We will have Mrs. Elizabeth Owe with a presentation. Honour members, I will now invite the presenter to take the floor.
Thank you, ma'am.
All right.
As I share my document, I want to also just appreciate the presentation made by Dr. Dikange concerning where we should be in terms of domestication and what parliamentarians should be doing. What I think we should take home as we do the work of this forum and as the committee, I think the basis is we are all familiar with the fact that the idea of the model laws emanates from the common purpose that the nations meet and agree on. And in as much as they've agreed on this common purpose, they also have their own social, economic, and cultural backgrounds that they need to go back to and put pen to paper to in order to domesticate documents, these model laws. And as such, it is necessary for this particular committee to continue to track what is being done. That being said, let me go to the terms of reference of the committee. As you spoke to, acting chairperson, in your opening remarks, the committee was established in 2018, and it was and the 43rd plenary assembly, during the 43rd plenary assembly in Luanda, Angola. And as a result of that, Article 16 of the Constitution provides for the Regional Parliamentary Model Laws Oversight Committee. What it does, this particular article, is it sets up the establishment such as it is in terms of the persons who would be members of the committee, and it also sets out the manner in which the chairperson and vice chairpersons are elected in their first meeting. The article also goes on to mention that there should be at least two statutory meetings in a given year, and it then now lists the functions, which I will read in in as short time as I possibly can. It is the committee's role to monitor and evaluate progress made by member states in domesticating SADC model laws and implementing related laws and policies. It is also the committee's role to advise the forum on the progress made by member states. The committee does this in order to fulfill the objectives of the various model laws that the forum will have formulated. The committee is also expected to support member states when it comes to measures and interventions addressing the various issues that may arise emanating from the model laws themselves when it comes to domestication. It is also the committee's role to facilitate awareness on specific issues in the model law and engage with appropriate authorities, grassroots and community-based organizations and the private sector. You will note, Madam Chairperson and honorable chairpersons and members present in this meeting, that this particular meeting consists of a number of stakeholders, and some of them actually come from the sectors that are mentioned in this particular section. That is community-based organizations, private sector, and the media. The committee is also expected to underscore the importance of addressing various development and governance-related issues during the consideration of member states and related matters. It is also a requirement that the committee pays particular attention to disadvantaged groups and marginalized communities in line with the provisions of the model law, as well as ensure that member states set out mechanisms or processes for the engagement of the public, mainly during committee sittings in the holistic, multi-sectoral manner, with a balance between preventative and protective measures as specified in the model laws. The committee is expected to also encourage the appropriate authorities of member states and other relevant actors to build on evidence. Likewise, the committee must also encourage national parliaments and appropriate authorities to establish a desk or focal person or subcommittees to coordinate actions on the various model laws. The committee is also expected to support national and regional efforts aimed at generating data through research, ensuring innovative community-based mechanisms and advocacy interventions, as well as support member states to set up functional monitoring mechanisms and establishing data collection. The committee is also expected to assist members in building the capacity of the relevant subject matters and law enforcement system to further the implementation of the model laws. The committee must share information on the various interventions and action plans with relevant stakeholders in SADC and beyond, and when requested elsewhere. And the committee must also facilitate coordination with other standing committees and the Regional Women Parliamentary Caucus on addressing issues relating to the implementation of the laws and policies in accordance with the objectives of the laws. Lastly, the committee is expected to formulate, develop, and make recommendations to the Executive Committee on oversight and accountability mechanisms in relation to the implementation of model laws. As you can see, honorable members, acting chairperson, that the committee has a lot of work that it is expected to delve into and succeed in. that being said, the question that may come to mind is, where does the funding come from? It is also provided for in the same article that funds available for use in relation to the committee shall consist of monies that may be allocated by the forum. And that is what I have to share with this meeting with regards to the mandate of the committee. With regards to priorities, the committee has the following priorities when it comes to this year. It is the intention that this committee will this year embark on 2 monitoring and evaluation processes, in particular, a benchmark with Zambia with regards to the domestication of model laws. The objective of this particular benchmark is to familiarize the committee with the context in which model laws are domesticated in Zambia through interface with stakeholders. This ties in well with the presentation just given by Dr. Dinganke, where he spoke of how it varies from jurisdiction to jurisdiction. So in as much as we come up with model laws as a region, it varies from one nation to another when it comes to domestication, the domestication process itself. And once the committee is familiar with the domestication process in Zambia, the intention of the benchmark visit is also to assess and document Zambia's progress in domesticating the model laws and to report to plenary. The second priority for this year is to monitor the domestication of the model law on child marriages in Zimbabwe. Currently, the Zimbabwean government is the Parliament of Zimbabwe is considering a marriage bill, and this is why this is a pertinent one. The objective here is to acquaint the committee with the context of the model law on child marriages and the extent to which it has been domesticated in Zimbabwe, and to document the progress in domesticating it in Zimbabwe. That being said, honorable members, we are also expecting to have 2 statutory meetings, this being the first statutory meeting this year. And I will give more detail in terms of expected outcomes in my next presentation. I end here, Madam Chair.
Thank you so much, Ms. Howe, for such an informative presentation. I'm sure as members of this committee, we are now fully aware of our duties and roles and what is expected of us as a committee. Honorable members, we move on to item 5, which is overview of the committee's work to date. Honorable members, I must recall Ms. Howe to take the floor again. Thank you.
Thank you, Madam Chair. For this particular presentation, I have a PowerPoint, but it seems to be struggling in terms, is it visible?
Yes.
Yes. Okay. So the title of this particular one is the overview as indicated by the acting chairperson. And the outline is, I'm simply going to re-emphasize the establishment of the, yes?
Can you kindly click on from beginning so there's a slideshow?
Oh, sorry. Thank you. Okay, so this is the outline that we're going to look through. I'm struggling to minimize my, okay, I found, okay. The committee was established in June 2018 and it held its inaugural meeting on the 6th, from the 6th to the 7th of May 2019 in Johannesburg, South Africa, ahead of the 45th Plenary Assembly session What emanated from that particular meeting is what we're going to speak about with regards to the committee's work as we continue. Like as indicated by the acting chairperson in her opening remarks, the committee is very young, it's in its infancy, and a lot needs to be done with regard to what their mandate is. So in the meeting of the 6th to the 7th of May 2019, it was agreed that there is an urgent need to prioritize the monitoring and domestication of legal provisions contained in model laws developed by the forum, and in view of that, promoting harmonization of regional legal norms on SRHR, gender equality and democratic elections across the SADC region, and ensuring that the SADC citizenry as a whole benefits from a standardized legal treatment implemented through sovereign parliamentary processes. Once again, the issue of sovereignty keeps coming up, and this is an issue that I feel the committee must be very alive to, because as we are all aware, we all come from different jurisdictions, and this is an issue that can affect the committee's work and the results that we anticipate. Because in every parliament, the debates differ, the mindset differs, so you don't actually have uniformity. So this is something that can be detrimental or may delay the work of the committee. The committee held its second meeting on the 28th and 29th of October in Johannesburg, South Africa again. And at that meeting, the committee recalled that it was its mandate to monitor and evaluate progress by member states in domesticating SADC model laws and related policies developed by the forum, and that there was an urgent need to develop targeted monitoring tools to assist the committee in its work. So my understanding of this, honorable members and acting chairperson and participants, is that this tracking tool is still to be developed, and this is also work that should be looked into. Emphasis was made that there was a need to strengthen the model laws in terms of the monitoring role, and drawing inspiration and sharing experiences and lessons from similar committees and bodies at regional and international levels, which systematically monitor legal systems in treaties and covenants and make progressive observations accordingly. It was also resolved that the forum, working together with national and regional interparliamentary bodies and institutional partners, should develop and institutionalize an operational framework and tools on effective tracking and monitoring mechanisms for model laws and related policies in order to streamline the work of the committee. The importance of evidence approaches was reiterated in tracking implementation and monitoring domestication. This is in order to take full advantage of existing and emerging opportunities in the various thematic areas covered by model laws, inter alia democratic elections, gender equality, and violence against women and children. The dynamics and thematic areas that are being looked at here, honorable members, also need you to bear in mind the uniqueness that we've been speaking to that relate to the sovereignty of each country. The committee also resolved that they shall utilize existing structures, processes, and procedures in respective member parliaments to collaborate in national parliaments in tracking implementation and monitoring domestication, including periodic reporting as will be determined from time to time. Hence the emphasis that there's the need for the committee to embark on these missions by virtual means due to the times that we're in, to ensure that we're able to continuously track and monitor what is happening with the national parliaments that are members of the forum. The committee also resolved that we should come up with innovative ways of pulling together technical and financial resources to support tracking, implementation, and monitoring domestication of model laws. So, past resolutions of the committee. The current committee met for the first time on the 25th of September 2020, where it elected office bearers. The committee also deliberated on its mandate and deliberated on possible priority areas in very broad terms. Which brings us to the priorities that we just spoke of. And the committee in that regard must be guided by the SADC Forum Strategic Plan of 2019 to 2023, which I will briefly share the mission, vision, and strategic objectives for the benefit of members, and so that as we continue to deliberate, we deliberate from one page. So the mission statement is to promote and facilitate the parliamentary processes necessary to enhance the oversight, legislative, budgetary, and representative roles of MPs at both national and regional levels by bridging the gaps between parliaments and citizens in view of positioning the SADC region as a cradle of participatory democracy. The vision statement is moving forward together as the flag bearer of democratization and socio-economic development of the SADC region. There are 7 strategic objectives in the strategic document of 2019 to 2023. The first being to promote interparliamentary cooperation, diplomacy, and dialogue on issues of regional interest in view of advancing democratization and socio-economic development for SADC member states. Number 2, to align, harmonize, and create operational and institutional linkages between SADC PF standing committees and programs and SADC organs and sectors in view of promoting integration and region. 3, to facilitate capacity development and other programs of support for members and staff of parliaments to augment skills, knowledge, and competencies to face emerging challenges. 4, to lobby and advocate equal and equitable representation of women and youth in political and decision-making positions. 5, to advocate and lobby for the establishment of SADC and the regional parliament through a phased transformation and with the approval of member parliaments and the SADC policy organs. 6, to formalize policy and operational relationships with the Pan-African Parliament, the Interparliamentary Union, the Commonwealth Parliamentary Association, and other interparliamentary bodies. And lastly, 7, to ensure the financial and human resource sustainability of the SADC PF through good governance and prudential planning. I must point out at this point, honorable members, and that the main 2 strategic objectives that we work with are strategic objective number 1 and number 2, but we must also be familiar with all of them for the purposes of our work. But we currently, as a committee, the committee's work is emphasized in strategic objective 1 and 2. So 2021 activities, I already alluded to the benchmark visit in Zambia. What I didn't mention is the expected outcome. The expected outcomes here are enhanced knowledge for the committee members on progress and on strategies for the implementation of laws in transboundary contexts such as border towns. And also the committee should be able to adopt and utilize best practices on the role of Parliament in the domestication of model laws. The expected outcome in monitoring the domestication of model child laws, paying particular reference to the Zimbabwean process currently underway, is to enhance the knowledge of the committee once again with the domestication of model laws in transboundary contexts, as well as the adoption and utilization of best practices. The statutory meetings aimed at achieving the objective of ensuring that the committee members are accustomed with matters under their purview and with the expected outcome of the enhanced domestication of model laws by national parliaments. We are currently in our April meeting and we hope to have a second statutory meeting in September. Thank you, merci, obrigado, asante sana, honorable members. I end my presentation here.
Thank you so much, Mrs. Howe, for the presentation. I'm sure we are now fully aware of our mandate you have given us the committee's work to date, what resolutions, what was resolved in 2019, and also strategic activities that we are going to, our strategic objectives that as a committee we are going to work with, and also the activities that are to be taken. Honourable members, I now give the floor to members if there are any questions. Do we have any questions from honourable members? Yes, honourable member from South Africa, you may have the floor.
Thank you very much. Mine's more comment than a question, and it's just to say thank you very much for the presentation. As I've always said before, this is more a roadmap than a prescript. You know, often one says that in our 15 countries we have a different host of rules and regulations and constitutions, so it's very hard to prescribe how it's going to be for every country. So I think the best way of encouraging all the countries is to say that, so, look, some of these countries already subscribe to the role model law, and some countries are far off the role model law. And I think it makes the role of the parliamentarians in SADC harder in the countries that are far off. But the best way to sell it is to make it a roadmap, is to make it look like a roadmap and how to reach it. And the best way is to show as the vision. And I think this is what we're trying to sell here, is the vision. And this committee is really, it's really selling this. It's almost like a sales group selling the vision. And I think that's the challenge. This terms of reference is really a challenge of selling this vision of 15 countries that are going to all look the same in uniformity, that are going to be the next generation. I think if we're honest with ourselves, the last tenure of SADC has been about loyalty, and it's been about a brotherhood. And I think the next generation of SADC is going to be about role model law and how we can all prescribe to this roadmap. Hopefully it's going to be about the legacy that we leave to the next generation, is about this roadmap that every country can follow. What I wanted to suggest, though, is that under COVID-19, we've seen that in Africa, many leaders have taken advantage of COVID-19 to make their people disadvantaged under elections, if we to believe the media. And that's almost been to the, you know, that they've taken opposition parties, they've intimidated them, they've used nefarious reasons to do what they've done to take third terms in office. How do we protect, in the role model law, things like COVID-19 happening again? So it doesn't necessarily have to be a COVID-19. Next time around, it could be a COVID-20, or it could be something else. What we should have in our role model law is something that caters for when there's a crisis that keeps us at home, or keeps the international community worried about themselves and not able to oversee or oversight countries on their own, where countries are left to their own devices. How does a role model law cater for that? Thank you very much.
Thank you so much, honourable member from South Africa, for those sentiments, and also the question that we have put forward. I'm sure the Secretariat has taken note of that. Thank you so much, honourable member. Are there any other questions, honourable members, before I give floor to Ms. Owe, maybe to comment on what honourable member from South Africa has put forward?
Honourable Chair, if you allow me, we have the citizens of SADC observing in this particular meeting, and previously they've been allowed to ask questions and intervene. At your pleasure, Honorable Chair, if you would like to invite them to take the floor.
Noted, Madam SG. They are welcome to come in and make comments or any questions. As we have said, all participants are now allowed to make questions or any comments. Okay, I have Ambassador Emmanuel. I recognize you.
Yes, thank you so much. Yeah, thank you so much. I would like to appreciate I had actually had a question
sorry,
that,
Ambassador,
in terms of the ratification.
Sorry, Ambassador, may you switch on your video, because the meeting is being broadcasting live.
Yes, thank you. Yes, I'm saying thank you so much for an excellent presentation that we're being made. I just wanted to inquire in terms of the ratification of the laws by the member states. To what extent are we as a regional bloc able to work on issues of protection for women, particularly in the internally displaced population settings? Particularly, you find when some laws have been domesticated by the nation, but to what extent are we also prioritizing displaced populations, particularly women, girls, and children, as far as social safety nets are concerned, as a SADC bloc? Because right now you look at what the African Union is doing, it's really something that I think is really commendable. But for us as a regional bloc, to what extent are we holding each other accountable as far as domestication of these particular laws are concerned? Thank you.
Thank you so much, Ambassador Emmanuel Gassa. Secretariat has taken note of that, and they will respond to that. Before they respond, can I take another question from the participants or honored members, so that we can have a set of 3? I have recognized Angela.
Thank you very much, Madam Chair. My name is Angela Machonesa. I work with Plan International in Africa, and we are very much concentrated in Southern Africa. So SADC model law is one of our key documents that we work with, and we are happy to be part of another SADC model law on gender-based violence. When I was listening to the conversation so far, it was only a few minutes ago when COVID-19 was mentioned. This means to say possibly, and also that the oversight meeting was not held last year. And we have seen the rampant effects of COVID-19 on the lives of the citizens of SADC, especially women and girls that we all serve. So my question therefore is, to what extent are all these tracking and tracking mechanisms and monitoring and provisions of SADC model law realistic to the prevailing conditions and contexts of the citizens of this sub-region? What are we going to put in terms of mechanisms to really cater for the effects that we have seen especially on gender injustice and a lot of services that are not accorded to women and girls, especially child marriage, as we are going to move swiftly to the questions around child marriage in the next season. How much are model laws alive to the challenges of COVID-19? Thank you very much.
Thank you so much, Angela. You have asked a very pertinent question, and I hope our secretariat have noted that and is going to respond. For those three questions, can I now give the floor to Mrs. Soe to respond? If you are ready, Mrs. Soe.
Madam Chair, I missed the, I was actually trying to get it through our partners, through my colleagues. I missed the question from South Africa. If I could just have the question, because I know to begin with he was commenting, but as he asked the question, I lost network. Could I please have the question and then we can respond accordingly?
Thank you, Mrs. Roy. South Africa, are you still there?
I'm here. The question basically in a nutshell is just that how would we cater for, if something like COVID-19 happens again, but maybe a COVID-20 or maybe some other crisis that causes international countries to go back into their shell and countries to fend for themselves. In the past, we've seen what happened with COVID-19, where certain countries, where leaders took third terms during elections, other leaders behaved badly according to media allegations, where they, what they did to opposition parties. How does a role model law cater for this?
Thank you so much, South Africa. Mrs. Hoy, did you get it now?
I got the question now. Let me begin with the question by Ambassador Gasa concerning social safety nets. Under what social safety nets the forum has with regards to prioritizing issues of gender-based violence and matters relating to women, and yes. I think this question will best be answered by the SG or Mr. Kurasha, so I'm going to ask to defer that question to them. When it comes to the question, I like the way you're laughing, Madam SG. When it comes to the question from Angela Machoni on whether we can find realistic mechanisms that cater for the effect in light of COVID-19, legislation generally is not, the idea behind legislation ordinarily is to cater for what is there or whether you're addressing a particular wrong. But where there are instances where something pops up, you then have to address it when it has popped up. COVID-19 happened in 2019. A lot of countries all over the world had to now fall into panic mode. Economies suffered. Social structures also suffered. Cultural structures also suffered. A lot of things had to be taken into consideration. What nations and regions did is they went into lockdown modes and they used their public health emergency legislation to address that issue. But whether or not there's a model law that is alive to COVID-19, the model laws that we are considering right now currently were not alive to COVID-19 because they came into life before COVID-19. But it is something that must be looked at. This is my view. And I would like to believe that it's a view of many, that there should be legislation. I think in the same vein, I'm answering South Africa's question in the sense that how do you cater for something that you're not expecting? It's very difficult to cater for it. But what I can say to you is, in as much as we suffered with COVID-19 and we went in our various directions, what ended up happening is systems had to be developed. We went virtual. Parliaments are now sitting virtually. There are very few parliaments that are convening to have meetings in one place. And most parliaments now have standing orders that also provide for virtual meetings and virtual means of voting and contributing towards the business of the day. So I think when it comes to your question, the one thing that I am failing to comprehend is how will people vote at national level? But then again, you can think of the cases of America where they do vote electronically by electronic means. So in as much as COVID-19 came and interrupted a lot of things for both Angela and South Africa, there are things that we've managed to cope in an environment that has allowed us to do so, thanks to the internet and those that created the internet and devices that have allowed us to continue with work at different levels in life. Lastly, yes, Madam SG, please assist me with the other question from Ambassador Gasa.
Maybe SG, before you take the floor and respond to all the most difficult questions, I wanted to add on the question by Honorable Bergman from South Africa regarding the predicament we face and limited focus by the international community in certain sections of the globe on account of the tragedies and pandemics such as COVID-19. One of the lessons we have learned with COVID-19 is the need to build the local capacity. Localization of capacities is no longer a luxury, as we saw from the supply chains, from the role of institutions. And I would think that the model laws represent an attempt to bridge the capacity gap and make sure that we have some level of self-sufficiency in terms of local capacity, including around the issues that are regulated by the model laws. And what COVID-19 did is to put into focus our own local institutions, for instance, parliaments. In instances where parliaments were reactive and not proactive, we saw the gaps that were created, particularly when the state of emergencies were promulgated. There were instances where parliaments, people were looking up to their parliamentarians, and the parliamentarians actually thought they were also locked down. They were also asking questions like everyone else. And eventually parliaments were able to come through, and we saw a coordinated effort, and the Parliamentary Forum played a critical role in that conversation where we started to interrogate and say, do we have sufficient legal framework, for instance, around the standing orders and the rules of procedures for parliaments to continue to operate during the lockdown, because the executive actions that were in operation still needed to be subjected to parliamentary oversight. So the point I raise and the challenge we put back to you, Honorable Bergman, as our political leaders in our respective countries, but also as a region, is really to post-COVID, to draw the lessons and make sure that we focus on optimizing local capacity, including our institutions such as Parliament, in the particularly on the accountability role, to make sure that you act as if you are the last man or woman in defense, and not to look elsewhere, because we have seen that the realities of pandemics means that everyone look at their immediate priorities, and we may be forgotten, and therefore we must look up to ourselves. And therefore we put back the challenge to our political leadership, in particular parliamentarians and parliaments. We need to localize capacity. We need to make sure that we are able to sufficiently deliver on this mandate, because in such situations, citizens do look up to us, and probably as the last hope. If parliaments don't perform their roles, the citizens have nowhere else to look. Thank you very much. I submit, Chair.
Thank you so much, Mr. Kurasha, for that intervention. You brought in very important ideas and also important points that, as honored members, I hope we have taken note of that. Madam SG, are you ready to come in?
Thank you, Chair. I'm not sure if I should retire my staff because I was sitting as an observer. Now they're deferring issues to me. However, let me just start with the issue of displacement crisis, as introduced by Ambassador here, and in a way alluded to by Honorable Darren Beckman. And just basically say the SADC Parliamentary Forum, because of the crisis in Mozambique, that has been a focus of this region, have already led by example and come up with a resolution condemning what is happening in Mozambique. This, I give as an example because the height of displacement in that country, in the north of Mozambique, which is estimated at about 700,000 people, lends legitimacy to the role of Parliament in discussing the issue of violation or violating human rights of citizens of this region. And I believe that it is very important for parliaments to begin to demand and apply themselves in terms of what systematic approaches the government have to promote the links between conflict, displacement, or terrorism, if you want to call it, and human rights abuses. What is it that can be done in the area of conflict prevention, if at all, that leads to such displacement? And if members of parliament can closely begin to link this thought process in the oversight interventions, it will go a long way in assisting the executive. Another issue that is quite important at the regional level, which SADC PF has been looking into, is to bring together policymakers, practitioners, researchers for a forward-looking discussion on some of these issues, around issues of peace building, around issues of ensuring that we articulate some of these prevention issues around crisis. And we are determined to make ourselves fit as an organization for providing an integrated development solution to such a complex problem. And this is where I would like to invite stakeholders who have research, who have data analysis capacity, who have evidence, and who are able to assist our members of parliament, where possible, to have early warning signs or to read into and analyze early warning signs at the scale at which will assist this integration with members of parliament to come forward and partner with the SADC Parliamentary Forum. This has been a preserve of the executive through the Troika on what is it called? Through the, I think it's the Peace and Security Troika, I forgot the name. And I believe that there is validity in bringing a human rights perspective into action to allow members of parliament to preach the do no harm principle, if at all, and ensure that we can be in a better position to escalate some of these solutions through guidelines. It may not be model laws, but guidelines through showing accountability through our actions as members of parliament to ask questions. And I believe this is how we can complement the many resolutions that have been taken at the UN level through the working groups that have been established on this matter, and also support SADC in terms of how they are bringing efforts to assist each other in peace building and building a security architecture in the SADC region. I'm just saying at this point, we are fit for purpose. If need be, come forward, let us develop toolkits to heighten due diligence of the members of parliament so that the respect for human rights, it is not just a principle, but is able to lead members of parliament to manage these risk and conflict settings or manage stakeholder input to ensure that we exchange best practice ultimately. Chair, that is as far as I can go regarding the issue that was asked by the ambassador. Regarding COVID-19, I would like to just say we have guidelines, we have a business continuity plan, we have sent guidelines to all our parliaments to report on what is happening in their parliaments. We recently had a meeting with the clerks and secretary generals to parliaments where they were sharing very progressive and cutting edge developments in their parliaments in terms of what they have done. At the SADC Parliamentary Forum, we're also looking at developing policies because this has really evolved into the need for any organization or any entity to plan for now and the future, as the members have already indicated. And one of the issues that I'd like to focus on, which may be relevant, is how we can do, there's been a call for the people's vaccine. There's been a call for vaccination towards herd immunity. There's been lapses here and here that we hear about. So one of the issues that we may want to look at in terms of guidelines, because I think a model law will take us maybe a little much more further. We can look at issues of supply chain actions, because at the end of the day, regardless of what happens, people want something to hang their hopes on. People are wondering, when am I getting the next vaccination? We've been hearing reports of people being turned back because they don't have underlying symptoms and therefore they cannot access this vaccine. But how do we then create transparency on such issues? How do we determine the critical information that should be shared through our representative role? How do we assess interruptions and risks so that we're able to advise government accordingly? How do we then optimize production and distribution of any, it could be the vaccine for now, or vaccine, I don't know, the next outbreak, what it will be. We've seen South Africa take a lead. It will be important for members of parliament to assess the impact on such operations, assess the impact on the available resources and capacities, meaning the workforce mainly, that we have in the region. How do we make sure that we get interested in ensuring employee safety and clearly communicate the actions that should be taken by each employer, or if need be, review our legislation. The other issue is to ensure that we're able to estimate the available resources that I've already spoken to, and make sure that at the end of the day, we rally and ensure that all the stakeholders, be it business, be it government or other multilateral partners, are brought on board without feeling that this resource is not going to go to the people. And mostly, I think this COVID situation has taught us a lot. How do we identify and secure logistic capacity in our countries? Because a lot of times we're hearing that, the vaccine has been ordered. It has not arrived. The vaccine has arrived, but it is not what it has to be. What collaborations do we need to leverage freight capacity jointly? And this brings us to the issue of movement of goods during such an epidemic. And I could go on and on, but I think the bottom line is that let's understand the chain stresses, the tests that we've gone through, and make sure that we understand what is required to be able to intervene at the policy level. I'm not yet further going into other areas, but I think it is very, very important for members of parliament looking at their roles to be able to say, how do we contribute to such, and how do we realistically demand, how do we ensure that our governments involve us so that ultimately we can be resilient for the future. Once we can deal with these immediate challenges that have been identified, we can lead and we can be able to design a resilient system that would take us further into many other epidemics. And ultimately, there's no going back. We need to invest in digitizing our systems. We cannot go back to a manual system. Otherwise, we will not be able to deal with the strengthened capabilities. We won't be able to anticipate risks into the future. We won't be able to coordinate and manage across any supply chain for the future. And therefore, This is a lesson. We don't have answers, but we believe that as legislators, you are at a critical point to maintain, to use your evidence to ensure that coronavirus pandemic subsides, if at all, that in the future, we're able to anticipate such risks that can emerge for any government. This crisis could have been better handled from what we read, but we can continue to hope that we've learned a lesson. I thank you, Chair.
Thank you so much, Madam SG, for coming in at such a short notice and giving comprehensive responses to those questions. Honourable members, do we have any more questions? Or you need some clarifications? I don't see any more hands being raised. Once again, thank you so much, Mrs. Oy, for the presentation. Honourable members and all participants, we now go to item number 7, presentation on the cost of inaction, key areas for domestication and oversight, focusing on the model law for eradication child marriages and protecting children already in marriages. Honourable members and partners, allow me to invite Mrs. Eva Jala to take the floor. Mrs. Eva.
Thank you very much, Madam Chair. Honourable members, SG, my colleagues in SADC PF, all protocols observed. Thank you very much for inviting me to present this very important topic. I think it will enhance all our knowledge in most of the questions put forward by the participants today. I am going to share my presentation with you. And before I do that, let me thank Professor Ndigani. I think he's laid the basis of what I'm going to say today. He underpins most of the concepts surrounding domestication of laws, and I'll just build on them. Okay. What's the problem? Okay. Some patience with this new technology.
Indeed.
Yeah, first, all of us need to do what? All of us need to bear in mind that what we need to do is stop child marriages, no matter what it takes. We must put in all our efforts in stopping child marriages. And to do so, I'll make a presentation based on the following: the objectives of the topic today, the general observations which I want to make before we go into the key areas of the model law that require domestication. Then we'll talk about a very important issue, which is effective oversight. Effective oversight, as you know, for the Regional Parliamentary Committee will depend a lot on what's happening in national parliaments. So your work will succeed if the national parliaments succeed in providing effective oversight. So it's an umbilical cord which is very difficult to cut. Then we'll look at the most important issue of the day, which is the cost of inaction. What happens if all of us just sit back? The objectives. The first and foremost objective is to fulfill the committee's theme of argumenting the enhanced execution of regional obligations by national parliaments. Assist the committee in actioning certain of its mandates as specified in Article 16 of the SADC PF Constitution. Ms. Hove read them out for us. They are so profound, and to succeed, we need to plan and strategize on how we are going to carry, or the committee is going to carry out those very extensive functions. Thirdly, point out key areas of the SADC model law, only key areas. It's quite huge, the model law, but we look at the key areas. And this is for the purposes of seeing which are the areas that require a lot of domestication and a lot of oversight. And lastly, consider the cost of inaction if the provisions of the SADC model law on eradicating child marriages and protecting children already in marriages are not domesticated by SADC member states. What are the implications? What are the consequences? Let me make general observations on the model law. I think it's important to give the committee some form of background, historical background, to put the model law in context so that we all appreciate why the committee is so concerned with the issue of child marriage. So the model law on eradicating child marriage and protecting children already in marriages responds to a resolution of the 35th SADC Parliamentary Forum Assembly held in Mauritius in June 2014, which called for the concerted efforts to eradicate child marriage in the SADC region. Very important. The model law was adopted by the SADC Parliamentary Forum at its 39th plenary session in Ezulini, Kingdom of Swaziland in 2016. Now, the question Professor has asked, and the question the chairperson also asked, it's now 5 years from that date. What has been done by member states? Everybody is concerned. You see, we never spoke to each other, the three of us, but we all had the same question because it's profound to the issues of child marriage. Let's look at the continental level. The African Union adopted a common position on the matter of the ending of child marriage, and in the ending of child marriages agreement, which signals the AU's commitment to empower women and girls and protect their human rights. The agreement was adopted by the AU Summit of Heads of State and Government. You can see it was high level. So the commitment is at high level. So we expect any actions and domestication to be at high level and to be followed up. Under the agreement, AU member states are to establish comprehensive action plans to end child marriages and establish and enforce laws which set the minimum age for marriage at 18 years, uniform across Africa. The AU will monitor progress towards this goal as part of its Agenda 2063 strategy, which aims to ensure positive transformation within the next 50 years. So as Africans, we know how to plan, how to strategize, but I think we've got a weakness: implementation. We need to jack up on implementation. Continue with my general observation. I want to point out to you another very important protocol, continental as well, Article 16 of the protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, which we call the Maputo Protocol. It provides that state parties shall ensure that women and men enjoy equal rights and are regarded as equal partners in marriage. They shall enact appropriate national legislative measures to guarantee that no marriage shall take place without the free and full consent of both parties. The minimum age of marriage for women shall be 18 years. Monogamy is encouraged as the preferred form of marriage, and that the rights of women in marriage and family, including in polygamous marital relationships, are promoted and protected. Every marriage shall be recorded in writing and registered in accordance with national laws in order to be legally recognized. The husband and wife shall, by mutual agreement, choose their matrimonial regime and place of residence. A woman and a man shall jointly contribute to safeguarding the interests of the family, protecting and educating their children. And it goes on and on. I just wanted to point out these very valuable provisions. Further, the model law is emphatic in some of its provisions to the issue of reproductive health for children and comprehensive sexuality education. In Africa, I don't know, we fear this word, sexuality. I'm not too sure why, but we pronounce on it. We pronounce on it. The World Health Organization defines reproductive health and rights as the rights of all couples and individuals to decide responsibly the number, spacing, and timing of their children, and to have information and means to do so, and the right to attain the highest standard of sexual and reproductive health, including the right of all to make decisions concerning reproduction free of discrimination, coercion, and violence. I'm just setting the stage for where we are going by my general observations. In addition, the Cairo Program for Action, adopted in 1994 at the International Conference on Population and Development, asserted that governments have the responsibility to meet individual reproductive needs and recommended a number of reproductive health services such as family planning, health, and safe childbirth, post-abortion care, and adolescent health. The program, among other things, identified some elements of reproductive health, such as satisfying and safe sex, capability to reproduce, and freedom to decide if, when, and how often to do so. In 1999, at the International Conference on Population and Development, ICPD+5, these were expanded to include AIDS education, research and prevention of mother-to-child transmission, and development of vaccines and micro besides. I think it's just a spelling error. So you can see I've even put, just to bring to the fore what it takes for women. Let's go now and turn to the model law itself and make general observation on the model law. That was the international setting, but now what was the purpose of the model law? The model law is meant to serve as a yardstick and an advocacy tool for legislatures in the SADC region. Provides best practice language and concepts which can be easily adapted by member states in their laws dealing with the eradication of child marriage, assist policymakers to address all the relevant areas in need of legislative reform without usurping the authority of national legislatures to determine the content, extent, style, and form of their national laws. This is important because, as Ms. Hove says, the question of sovereignty keeps coming up. But really, you are members of one forum, you have sat in agreement, and you want to communicate your agreement to your national legislatures to implement. So sovereignty must take a sidestep for you to be able to fulfill the intentions of what your people want. Create a robust and uniform legal framework relating to child marriage in the SADC region as a key path to addressing child marriages. Child marriages are not, they're not limited or restricted to one area. They expand, there's cross-border movement of persons which need to be dealt with. So the best way of doing it is to create a uniform law so that perpetrators don't escape into a region which has no law at all on child marriages, and it's business as usual. And encourage governments to be accountable in the execution of policies, enactment of laws, and coming up with strategic plans aimed at addressing child marriages. So this is just in a nutshell what the objective of the model law is. Another important observation is that the eradication of child marriage using a human rights-based approach is of absolute importance if the legislative intent is to be achieved. And as Professor said, the SADC model laws are good at this. They always look at the human rights of people and try to base all their model laws using this approach. And it's a very good approach to use because member states have already committed themselves at regional, continental, and international levels to observing and upholding the human rights of their people. It is a truism that child marriage is a violation of a child's human rights and fundamental freedoms and impacts on reproductive health rights as provided for in a number of international and regional programs and agreements. Therefore, any law dealing with child marriage must be underpinned by a strong restatement of a child's rights and the principles and concepts on the best interests of the child, including reproductive health rights and sexuality. I'll discuss this in a little bit more detail later in the presentation. Domestication of human rights. Professor has already talked to a large extent on this, but I need to say just a little bit more to remind ourselves. As I keep emphasizing, the model law is derived from a number of human rights instruments which need to find their way into national legislation, which will in turn domesticate the state's international commitments and obligation on human rights, thus reaching milestones in eradicating child marriages. So you can see it has a pinball effect. National law will determine, as Professor has said, whether an international or regional instrument automatically becomes domestically binding once it has become internationally binding, or whether implementing legislation is still required. In Zambia, this process is regulated by an act of parliament deriving from the Constitution. So at least it's sealed because they came up with an act of parliament. In some countries, an international treaty automatically becomes binding national law when it enters into force for the country. That's a monist concept, as Professor already pointed out. To some extent only, we find this in the South African Constitution. As such, it directly creates rights and obligations for national actors, even without implementing legislation. Nevertheless, the text of a treaty may not be specific enough to allow direct application at the country level. If legislation or regulations are required to clarify the rights and obligations of the national actors, then the country will domesticate the international instruments. And obviously, this must be done through the applicable parliamentary procedures. So that's even where you are using the monist concept. In other countries, international treaties do not become immediately binding at the national level, the dualist concept. Zambia and most SMS SADC member state countries. They must first be transposed into national legislation, which establishes the corresponding rights and obligations. The legislation will also have to be adopted through the applicable national legislative procedures. So you see, we can't run away from this issue of sovereignty and balancing the powers of national legislatures with that of the executive, or recognizing the fundamental role the executives in our countries play. They play such a fundamental role as they will direct the way the country goes at the end of the day. No wonder why we need effective oversight over them. So, as parliamentarians and members of the SADC-PF and members of the Regional Parliamentary Model Laws Oversight Committee, have you seen the role you are playing? You as members of this committee, you are playing 2-3 roles. You are wearing 2-3 caps at the same time. You are so fundamental to the success of our domestication process. In accordance with your terms of reference under the SADC Constitution, to hold the executive accountable for domestication of model laws. You are basically doing that through the national legislatures. You are trying to hold the executive accountable for domestication of model laws, of not really the model law, but the provisions of the model laws that derive from international instruments, using your oversight functions. It is important that you effectively carry out your constitutional functions and be assertive and proactive in ensuring that the executive domesticates its national obligations as members of parliament in your own legislatures, first and foremost. As a Regional Parliamentary Model Laws Oversight Committee of the SADC-PF, SADC-PF itself will need to strengthen you with maybe, as someone was saying earlier, added advisory services. For example, establishing external advisory structures composed of civil society organization, academia, and experts in subject areas to assist the committee, carry out fundamental research, carry out tracking, getting evidence-based information and data in order to help national parliamentary committees in trying to hold the executive accountable. And I'll dwell on this when I come to the key areas of the model law and how you can effectively oversee the executive in certain of the provisions which are already specified in the model law. As a regional parliamentary committee, you must be knowledgeable of all SADC model laws. I think that's very important. If you are very knowledgeable of all SADC model law and the processes of domestication in SADC member states, you will be able to carry out your important functions under Article 16. But at the same time, that knowledge must be tied with effective response from you to community needs by creating effective collaboration networks. Without effective collaboration networks, you'll find your profound mandates, as read to us by Ms. Hove, as very difficult, as very, very difficult. So yours is not an easy task, but it has to be done. We understand, at least SADC PF understands, that there are a number of challenges in SMSs that may be a hindrance to the eradication of child marriage using the domestication process. Some of which are as follows: lack of effective and well-streamlined birth registration systems, making age determination difficult for purposes of enforcing a law on child marriage. Obviously, when the executive takes to Parliament a bill, they have already done their homework. They've done their research. They have looked at their policies, and they know whether they've got adequate capacity to implement that law. So if they don't have adequate birth registration systems, how will they determine minimum age of a person is 18 years, the minimum age of marriage? It's very difficult. So these are some of the challenges. In Zambia, for example, most of us don't have birth certificates because it only came into being for Africans after 1973. So we always just swear to affidavits. Those are challenges. Those are challenges. So fixing the birth registration system becomes imperative before governments can take some of these laws into Parliament. This is just an example. Sometimes there are no provisions in the law penalizing those who contravene the minimum age of marriage requirement. You find some of these laws, they were taking them as civil contractual laws and no penalties. You find maybe general penalties in the penal codes, and these are not adequate, or they contradict what is stated in the substantive laws. Slow reform in laws that impact on eradicating child marriage, which may frustrate interventions to prevent child marriage. And there are many of these. I'm sure some of you can relate to these other laws. Quickly, I can read some out to you. There's laws on sexual offenses, laws relating to gender inequity, laws relating to anti-gender-based violence, penal laws, anti-trafficking laws, child justice laws, marriage laws, adoption laws, legitimacy laws, citizenship laws, laws on refugees, maintenance and affiliation laws, termination of pregnancy laws, education laws, health laws, empowerment laws, and labor laws. These are just some of them. Now, for you to domesticate a child marriage law, you must put in place or ensure consequential legislation are done to some of these laws which I've just read out. So this process is very slow in some member states. We need to have some mechanism to jumpstart reforms, expansive reforms, and not just reforms in one small area or one law, and then you leave the others hanging where you have problems during implementation. Especially so that in our countries, you find there's multiple institutions dealing or having the portfolio of some of these laws. We need to do something there. There still exist some cultural, religious, and traditional practices that infringe on the rights of children and create power relations between women and men that favor the latter in the domestic, community, and public domains and impede the advancement of women. Change. How do you achieve change in society? How do we do that? So that we can ensure domestication is smooth. And once we have domesticated, we can implement smoothly without leaving any person behind in our countries. Just because I live in the rural areas, I must not be protected. No, I must also be protected, although that culture and tradition is hanging heavily on my shoulders. Attitudes and behavior which resist change with a belief that the old way of doing things is fine, making reforms difficult and change management even more difficult. These are only some of the challenges that exist to domestication, fulfilling domestication. Let me leave my general observations because I become very passionate of what's happening in our societies. Very passionate about it. But we have to do something. We have to do something. So let us look at the key provisions of the model law for domestication. Which are the areas must we concentrate on so we can fulfill our intent, at least the SADC PF intent in the model law? The model law addresses 7 main thematic areas: restatement of rights and concepts relating to the child and related policies, prohibitions on betrothals and child marriages, measures and interventions to prevent child marriages, measures and interventions to mitigate the effects of child marriage, access to data and information, public awareness and monitoring, and offenses and enforcement. So these thematic areas were all derived from evidence-based research on the incidences of child betrothal and child marriage, and recommended best practices contained in a variety of regional and international instruments, documents, articles, and literature on child betrothals. I wish I couldn't be using this word, it ties my tongue. Child marriage and children already in marriage, published by UN bodies and other renowned authors on the subject. So it's very much evidence-based, the model law. The model law aims to assist member states in SADC to enact legislation which is in conformity with international and regional human rights instruments. It provides, SADC to provide in their policies and legislation strategies, measures and interventions to fulfill a child's rights and eradicate child marriages, such as right to education, health, and reproductive rights, and the right to be free from all forms of harmful practices and violence. To make child marriages already contracted voidable on the option of a partner to the marriage, who was a child at the time the marriage was contracted, or the option may be exercised by either or both parties. So overall, this is what it's done, but we still got some more objectives coming. To also provide supportive, basic and uniform provisions for legislation in SMSs, such as providing for a minimum age of marriage and capacity to contract a marriage, provision of legal aid, custody and maintenance of offspring, and legitimacy of offspring of prohibited marriages. We found that some countries, some of these prohibited marriages, the children become illegitimate, and that affects the inheritance rights and so many rights. Provide for prohibitions on the solemnization of child marriage, enabling a court to issue restraining orders and putting in place programs and incentives to delay marriage. Provide for a mechanism to determine when a child is in need of care and protection so as to protect children already in marriages and victims of child marriages. Provide for establishment of places of safety for the residents and maintenance of victims of child marriage. Provide for the training of key government officials, especially the police, law enforcement officers. We really need to do something there. Provide for the monitoring, evaluation, enforcement, and public awareness of the negative effects of child marriages, and provide for the establishment of an anti-child marriage fund. We find that most of these interventions and measures can't work because there's not adequate funding. We are all depending on the international community to come and fix our problems. We need to do something from our own revenues to show commitment to fighting this, I don't know, call it an endemic, pandemic, or whatever. Let's just look now at the key provisions of the model law. And I've just selected a very few, just to bring to the fore the focus of the law. So some of the following are essential and must be included in any law on child marriage. So the best interest of the child. I don't know whether I should read it because I think most of us know the concept, is that the best interest of the child must be paramount in considering of any matter, decision, or action of any state authority. What is important is to safeguard and promote the welfare of the child, and to ensure that the child gets adequate guidance and justice in all matters related to the child. Further, we also look at the capacity of the child. A child who is capable of forming his or own views shall be accorded an opportunity to express that child's opinion in any matter, decision, action, or procedure affecting the child, and that opinion shall be taken into account as may be appropriate, having regard to the age and maturity of the child and the nature of the matter, decision, action, or procedure. A child is a human being and has human rights, just as you and me have them. There's another important provision that is inserted, is a right to protection from discrimination. You cannot discriminate against a child. And there's two instances how this can happen. There's discrimination against a child on grounds of race, color, his own status. And there's discrimination and punishments against a child because of the status of the child's parent or relative. So both forms of discrimination have been taken into account. Another issue we've emphasized throughout the model law is the equality right, the right to life, the right of privacy, dignity, and respect. And this comes to the fore when we are talking about the health rights of the child. privacy, dignity, and respect. Because a child is equal before the law. The child is entitled to the full protection of the law. And the child has a right to life. And the child has a right to privacy, dignity, and respect. So the law emphasizes that every government and judicial authority must ensure that all children, whether born in or outside marriage, are treated equally and before the law, and equal before the law, and are accorded equal protection and rights. And a child's inherent right to life decision must be upheld at all times. Protection from child marriage, sexual exploitation, and abuse. A child has a right not to be married. They are children. A child shall not be subjected to sexual abuse or exploitation, or used in prostitution, inducement, or coercion to engage in any sexual activity or exposure to obscene or pornographic materials. We are all going now for cyber legislation, and it's targeting this very issue. So part of this has already been domesticated in some countries, at least in Zambia. So the member states have already committed themselves to these human rights and standards when they signed or ratified international regional human rights instruments. Let me remind you of an old UN convention, which was done in 1962. It was on consent to marriage, minimum age for marriage, and registration of marriage, which reaffirmed that all states should take all appropriate measures with a view to abolishing such customs, ancient laws, and practices by ensuring inter alia complete freedom in the choice of a spouse, eliminating completely child marriages and the betrothal of young girls before the age of puberty, establishing appropriate penalties where necessary, and establishing a civil or other register in which all marriages will be recorded. This convention has been upgraded many times over from 1962, both at regional, continental, and international levels. But it reminds us that even at that time, those concerns were there and they are still here. Protection from harmful practices. Professor has touched on this one. The model law ensures that the ministers responsible for areas which are prone to introducing these harmful practices in our societies take adequate measures and stop the practice of these harmful practices. So the child laws identifies all those areas and brings in for prohibitions in relation to those. We wish to emphasize that in this respect, the ministers responsible must collaborate with all other relevant appropriate authorities, including traditional leaders, religious leaders, to comprehensively and regularly investigate and recommend for review all harmful practices that have been previously condoned and have subjected children into misery. So there's a prohibition there, which is a person shall not use or impose, subject or encourage another person to use or impose a harmful practice on a child. Turning now to effective oversight over some of those provisions. I need to emphasize that the successful and efficient oversight of the implementation of the provisions of the model law and subsequent enacted laws, once it's been domesticated, we can't forget. We still need to have oversight over those laws. will depend on how the legislature will use the provisions of the model law relating to, for example, monitoring the statistics of, on child marriages, how programs are being undertaken or made compulsory, for example, whether educational institutions are delivering lectures on the nature, causes, and consequences of child marriage, and the consequences of traditional and customary initiations programs as components of a comprehensive sexuality education subject in public and private learning institutions, including vocational, non-formal, indigenous learning systems, and religious institutions. Information and data on child-related issues based on aged. Each time I put aged, someone keeps putting age for me, but it's aged, meaning tested, it's old and tested, appropriate, scientifically accurate, evidence-informed, and human rights data and information. Maintenance of public records, which can be easily assessed, data retrieved, and disseminated efficiently while protecting critical data, such as personal data, to ensure the privacy of the child. Public record keeping is poor in most of our countries, but parliaments, even the parliament, you as the the regional parliamentary committee, must push on this. Without clear and good public record keeping, your job will be 10 times harder. This needs to be constantly on your radar. Monitoring and evaluating the programs and incentives to delay child marriage established or not established by the government, including the following. You have to keep monitoring these programs, whether they've been established or not established. Opportunities for girls to continue their primary and secondary education, including life skills and vocational training. Opportunities to families, girls and boys, to earn money through entrepreneurship and work in the public sector through human resource development programs. Supporting programs that retain girls in school. Supporting alternative forms of positive discrimination and broadening opportunities for girl education. Supporting innovative programs to adolescent girls that may help provide preferred alternatives to marriage. Targeting families in communities where child marriage is most prevalent by providing advocacy on the dangers and effects of child marriage, and supporting awareness programs in primary and secondary schools on the right not to marry before the age of. So your oversight is actually looking back to the model law and see what the model law provides in these areas and determine, is government doing this or not? If not, what must be done? Monitoring and evaluating mitigatory measures and interventions that the executive has put in place or not put in place to mitigate the effects of child marriage, and whether these are being or not being funded from the Anti-Child Marriage Fund, such as establishment of public safety homes, public foster homes, or any other public facility for the residence, care, and maintenance of victims of child marriage. Monitoring and evaluating measures, interventions, and entitlements for children in need of care and protection, such as assistance and maintenance for children, appropriate health facilities for the treatment, counseling, rehabilitation, and care of children, and other facilities, programs, and support structures, and appropriate measures and interventions to promote the safety, physical, and psychological rehabilitation of children. Put under constant surveillance community networks and monitor the development of community centers to provide for psychological and physical support to girls who run away from children. I think this is very important. The mental health of children hasn't been exposed to most of us in Africa. We need to pay more attention to that, because these are our future resources. Provide emergency facilities where victims of child marriage can be accommodated and cared for, Support reintegration of victims of child marriages with their parents. How is this being done? What is the evidence that it's being done? Parliaments need to push on these issues. Otherwise, nothing actually is being done in relation to reintegration. There's very little. Reintegrate victims of child marriage into society and launch child advocacy programs for the prevention of child marriage and reporting child marriages and children in need of care and protection to a child marriage prohibition officer or other appropriate officer. Have these child marriage prohibition officers been established? If not, why? Why haven't they been established? Check whether or not the executors developed and are implementing effective evidence-based policies and programs for eradicating child marriage. Paying attention to whether it has set up disaggregated data collection, child surveillance systems, and national child rights observatories in line with the objectives of the African Regional Charter on the Welfare of Children and the CRC. Now, let us look at the cost of inaction. At least I'm coming to an end now. I'm sorry for taking so long. But I think these issues are very important. There is empirical evidence emanating from various research undertaken by various groups and individuals showing that child marriage has a specific negative implications on children, ranging from restriction of their personal freedom to impact on health and education. For boys and girls alike, an early marriage has far-reaching physical, intellectual, psychological, and emotional consequences. For example, serious threat to sexual and reproductive health, maternal and newborn mortality and morbidity, obstetric fistula, and sexually transmitted infections, including HIV and AIDS. It is also a truism that the dimensions of gender, including customs, economic, political, and legal, play a crucial role in determining the cost of inaction, especially as customs do not provide for automatic changed social or economic conditions that may undercut the rationality of a custom. When change occurs, there is usually a time lag in adjusting practices to new conditions, since norms always resist change. So this is fundamental to domestication, customs and tradition, because they lag behind. Change is often very difficult. Therefore, it is important to act as inaction is costly and may result in undermining the legislative function and the state at regional and international levels. Let us look at the Vienna Convention, because I think we make too many excuses when it comes to domestication. We all are parties to the Vienna Convention on the Law of Treaties of 1969, which can best be described as a codification of public international law. The convention defines a treaty as: treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. So agreement, treaty, convention, protocol. Most SADC countries, if not all, are state members, state parties to many instruments that are governed by public international law. These are entitled treaties, conventions, as I said. For example, an exchange of instruments in any form, often through diplomatic notes or letters, can be a treaty covered by the definition. So Article 26, oh no, I've missed it. Article 26 of the convention states, every treaty in force is binding upon the parties to it and must be performed by them in good faith. And Article 27 states, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This convention has implications on inaction. Your inaction to domesticate something which you have agreed on and committed to. Domestication, as you know, as Professor pointed out, is a means by which the government can show its commitment to operationalizing its international obligations, thereby adding value to the quality of life of the people. The best instrument of governance is the tool, is the highest instrument of governance. And the highest objective of a government is to ensure the high value, quality, high life value life of its people. The best interests of its people come first. From a legal or human rights perspective, you'll find that non-domestication poses challenges for operationalization of international conventions, as any inaction means denial of the immediate protection of persons trying to access the rights offered under international instruments. People have no way to turn because they are waiting for domestication. Meanwhile, their rights are being trampled upon. A child's right is being trampled upon. Further, by domestication, Parliament is given the opportunity to make ancillary provisions to ensure that the institutional, administrative, and financial infrastructure of the state is able to implement the international or regional instruments without which a person cannot effectively enjoy the human rights. Introduce penal and other enforcement provisions or fiscal provisions for effective implementation of the law, as lack of adequate compliance and enforcement measures makes a law inefficacious without the impact it was intended to have. So we need a law domesticating those instruments which are very loose and cannot be effective in national jurisdictions, and reinforce a commonality of regional approaches in dealing with child-related laws, measures, and strategies to help eliminate child marriage. Without a domesticated law or domesticating law, these can't be achieved. By domestication, national legislations can achieve institutionalized systems, which is very important. Institutionalized systems, no criteria, no discretion, no discretion, and subjective criteria has been used to eradicate child marriages. And the domesticating law will act as a guide to all institutions, both private and public, as to the measures that must be put in place to achieve effective eradication of child marriages and encourage and develop good practices to prevent it happening. Further, all laws which impact on the economic dimension of gender and impact negatively on achieving the objectives of socio-economic development are a danger to society and must be eradicated. Thus, failure to use the model law as a tool to assist SMSs develop and enact national laws on ending child marriage and reforming existing laws on marriage in line with international, continental, and regional commitments relating to human rights, and more specifically against child marriages, is a serious disservice to the people and the child, because the underlying rationale is to protect children, punish perpetrators, and ensure that human rights are upheld in accordance with international, continental, and regional standards and requirements. So, coming to the end of my presentation, what is the role of SADC-PF and how do we keep the momentum going? It's important to keep the momentum on the SADC model law on child marriages going, as its provisions impact on socioeconomic development and sustainability. This is despite the many challenges that may be faced in domestication and implementation of its provisions. This is despite also the fact that national parliamentary committees may suffer a number of obstacles in their work as MPs, especially relating to lack of research capacity, lack of legislative drafting capacities, technical know-how, time given for investigations and consultations, advisory facilities, and time for initiating private members' bills, which is often insufficient and costly. These are the challenges which are a reality, and we have to deal with them. Otherwise, there will be no domestication. However, if the legislature is to be effective in carrying out its constitutional functions, and thus help the regional parliamentary committee, the MPs must be assertive and proactive in the manner they perform their functions. The proactive approach requires that an MP acts in anticipation, takes control, and exercises self-initiative. Must be well-versed in legislative analysis and scrutiny. It is a truism that parliamentary committees need strengthening with added advisory services. Parliamentary committees need to effectively respond to communities' needs by creating effective collaborative networks. There is need for continuous training of parliamentarians in policy development, legislative analysis, and scrutiny, and other relevant subjects related to their oversight function. Otherwise, you will not be able to keep the momentum on the child marriage, model law on child marriage. Thank you very, very much for your patience. I know I've taken long, but again, the message, stop child marriage. Thank you.
Thank you so much, Mrs. Eva Jara, for a well-researched presentation. Honourable members, allow me to invite Goodwill Ambassador, Miss Nyaradzai, for her to take the floor so that they can now take questions together after she has given her presentation. Miss Nyaradzai, are you there? Miss Nyaradzai?
She is online. May we kindly unshare, Miss Eva?
Is she online?
Yeah, I'm trying to.
Yes, she is online.
Okay.
I'm not sure. I think she'll take the floor.
Okay.
Okay, I'm trying. Let me just go. Just come in. It's here. Just I want to unshare.
So welcome back. Here the top stories again.
Secretariat.
Industrial relations problem with all the impact hearing between the main.
Don't go first.
Colleges agree to
But why don't you just go after?
Association of Malawi BAM introduces player transfer regulations to control professional.
Hello, Secretary.
Chair,
Yes,
Ms. Hoven, kindly check quickly if Ms. Nyaradzai if the Goodwill Ambassador is taking the floor. We are fast approaching 12:30.
She has not taken the floor yet, ma'am. Let me try and ring her.
There she is, she's online.
Well, welcome, Ms. Nyarazak. You may take the floor now.
She's speaking, but we cannot hear her. We can't hear you.
I think she's muted.
Yeah, she's muted.
Kindly unmute, Ms. Nyarazai. We have not heard you. Okay,
Maybe
she's struggling with connection.
Maybe the host can assist.
I think she's trying to connect. She's indicating on the chat.
Mrs. O?
She's come back. Honorable Chairperson, she misses the AU ambassador. Ms. Gumbo Nanja has come back online and she's unmuted now.
Thank you so much. Mrs. Gumboza, you may take the floor.
We still have no sound.
Connection.
Don't know.
I'm trying to get my audio and I'll call in by phone short.
Ronald, is there any way we can help her with sound? Because we can see that she's talking, but there's no sound.
No.
Your guidance, Madam SG?
Connected.
She's connected now?
She is connected, but she's not saying anything. Now she's muted.
She is still muted.
Okay, now, okay, she was unmuted for a second there.
Okay. She's unmuted.
Do we have her now?
Yes, we have her number. Let me try and call her. I don't know whether she's using the same gadget for logging in and her telephone, because okay, she's indicated in the chat that she's trying to get her audio sorted and she'll call in by phone shortly. Perhaps she could call on my phone.
Just let her know.
Maybe, Chair, in the interim, we could see if there will be indication for questions.
Okay, Madam SG. Honourable members, do we have anyone for questions or seeking clarification on the presentation that Madam Eva has just done? You can raise your hands. Madam SC, I don't see any hands. Your guidance, please.
Indeed, Chair, that means that is the position. Oh, we have Angola.
I've seen Angola, Madam Chair. Angola had a hand up. Angola.
Yeah, Angola.
Honourable member from Angola, you may take the floor.
Muito obrigada. Muito bom dia a todos. Bom dia, senhora secretária-geral. Eu queria apenas fazer uns comentários sobre os efeitos da lei modelo. Penso que a lei modelo vem dar uma grande ajuda no sentido de uniformizar os regimes jurídicos dos países membros da SADC nesta matéria de casamentos precoces. Em Angola, o regime jurídico angolano tem abordado de forma satisfatória a situação dos casamentos precoces. A nossa lei prevê que uma menor de 16 anos só pode casar-se com autorização dos pais. E os casamentos normais são as jovens a partir dos 18 anos. Quem tiver 18 anos pode casar à vontade, quem tiver menos de 18 anos só pode casar com autorização dos pais. A lei modelo tem sido analisada aqui em Angola e, neste momento, está no Ministério da Ação Social, Família e Promoção da Mulher para análise e possível enquadramento com o nosso regime jurídico. Ainda em relação... Sendo que, pronto, já disse há bocado que com algumas exceções pode haver casamento com 16 anos. Em relação aos registros de nascimento, que também a senhora oradora falou, e muito bem, e felicito-a pela sua excelente abordagem, os registros de nascimento em Angola...
Okay, so what the chair was suggesting is that you speak through my phone. So I'll just put my phone by my device. when you are now speaking.
Posso
Right now we've
continuar?
gone into plenary
Posso?
over the
Posso continuar?
then after that you can. So I'll just keep this
Ms.
phone
Hove, kindly
open
mute
just and keep
yourself.
this going while we wait for her to invite you so that you can communicate that way.
Ms. Hove, kindly mute for Honorable Nascimento to finish the intervention on the floor. Yes.
Eu estava a fazer um comentário sobre a questão dos casamentos precoces. Também foi falado pela nossa oradora que falou nos registros de nascimento. Eu gostaria aqui de dizer que, quanto aos registros de nascimento, o Ministério da Justiça de Angola está a realizar já há 3 anos uma campanha massiva de registros de nascimento. Todas as crianças, inclusive estudantes, que não estejam, que não tenham sido registados, são registados, mesmo aqueles que já andam na escola, se estão na escola, mas não têm um registro de batizado. Aos sábados há brigadas que vão às escolas e que fazem os registros, mesmo nas escolas. Também foi aqui falado na questão das vacinas. Gostava de dizer que, de facto, o Covid-19 criou um problema muito grande a nível da África e a nível de todo o mundo. Em Angola foi criada uma comissão interministerial que tem coordenado todas as atividades ligadas à pandemia da Covid-19 e tem dado resultados positivos. Existem vacinas, existe um plano nacional de vacinação que está a ser implementado. Começou pelos médicos, pelos professores, pelas pessoas de idade superior aos 60 anos. Neste momento está a funcionar nas províncias. Angola tem 18 províncias e este plano de vacinação vai abranger todas as províncias de Angola. Portanto, esta era a informação que eu gostaria de dar sobre o casamento precoce, que já dei, que está no Ministério da Família neste momento, Ministério da Ação Social, Família e Promoção da Mulher, para análise e possível enquadramento no nosso regime jurídico. E já dei também a informação sobre os registros de nascimento e também sobre as vacinas. Não sei se alguém quererá fazer alguma pergunta, se não, e se for, estarei à disposição. Muito obrigado. I'm finished.
Thank you so much, Honorable Maria from Angola, for sharing with us the path that the Angolan government has taken in the eradication of child marriage and protection of children already in marriage, and also on the vaccination that is going on worldwide. Honorable members, allow me now to invite Ms. Nyaradzai to give us her presentation. Ms. Nyaradzai, are you ready?
Yes, I am. Thank you, Chair.
Ms. Hoy?
Yes, ma'am. I've got the AU ambassador on the phone.
Hello, can you hear me on the screen?
Oh, yes, we can. So let me drop the call.
Yes, we can hear you.
Thank you, switch off. Thank you very much. Let me start by thanking you, Honorable Chair, and your committee for your tolerance, your patience, your understanding of African technology access, but more importantly, thank you, Chair, and your committee for having me present with you today. I want to recognize you. I want to recognize the Secretary General and her team. Yes, can you hear me now, Chair?
Proceed, Honorable. I think the Chair can hear you.
Thank you. Thank you very much. It is indeed an honor for me to address this meeting of the SADC Parliamentary Forum Oversight Committee on my mandate as the African Union Goodwill Ambassador on Ending Child Marriage, and indeed as a citizen of the SADC region, as I bring you greetings from my village where I am based in Zimbabwe. Let me at the outset start by congratulating you for the procedures that you have adopted and continue to adopt for your meetings. I was very much encouraged to see an inclusive process that is welcoming of a diversity of participants, including citizens from the SADC region, and also the expertise and experiences that you are all bringing. It is an honor for me to accompany you, to accompany the SADC Parliamentary Forum from the time when you were developing the SADC model law on ending child marriage, and the momentous occasion when I was present there in Eswatini, when you adopted the SADC model law on ending child marriage. I sat in that room when you had the deep scrutiny, word by word, sentence by sentence. And at the end of the day, with such a long document, there was consensus. Again, congratulations. It therefore, for me, signaled at that moment the seriousness within which our SADC parliamentarians are taking the matter and the issue of children's rights and the future of our region, and therefore always wished and committed, even on that day, that I'll do all I can to support your efforts to accompany you. In October 2019, I had the opportunity to participate in your meeting of the Oversight Committee in Johannesburg. And at that moment, it was at your generous invitation and that of the former SADC Parliamentary Forum Oversight Committee Chair, His Excellency, the now President of Seychelles. I sat in that room and felt again the pride of being an African woman, of being a citizen of this region, because not only was I listening to a precedent-setting agenda on accountability and monitoring, for which the Oversight Committee is, that you are an accountability and monitoring mechanism within the legislative space for our work on ending child marriage. This does not exist in any of the regional economic communities of Africa. The SADC model law in itself is precedent-setting and is groundbreaking. Therefore, for us at the continental level, we are looking up to the Oversight Committee to continue to define the path and inform and instruct and give inspiration to also the institutions that we have, knowing that we have the continental commitment. The African Union continues to be highly committed to the core values of a prosperous Africa that is at peace with itself. We know that Africa cannot be prosperous nor at peace with itself if we continue to experience the violence that people experience, if we continue to have the sexual abuse and the gender inequalities that we have. It means the continent is not unleashing the potential of over 50% of its population, and therefore the investment and focus on children's rights, on women's rights, it's a matter of obligation, it's not a matter of charity, and we want to appreciate this effort. The AU launched its campaign to end child marriage in 2014, and it was in 2015 at the SADC Heads of States and Summit in South Africa that we had the adoption of the Africa Common Position, as has been ably elaborated by Honorable Eva Jala. And indeed, for us, the SADC Parliamentary Forum and the SADC efforts started and already had opened the pathway around how do we bring meaning and value and effort to these continental commitments for them to be meaningful and impactful at the regional level. And we continue to also appreciate the support of President Edgar Lungu of Zambia, who is the presidential champion within the African Union on ending child marriage. Our request, and my request as the goodwill ambassador, my mandate is to be an advocate and to push for issues. My request is, through the work of the SADC Parliamentary Forum, is also for us to have a SADC Heads of States commitment, just like we have the AU Summit commitments. If through the work that you are doing, the work of the presidential champion, we also need a political commitment of our African Heads of States at the SADC level, so that they can also work closely and push the legislative and support the legislative effort within the various countries. We recognize that COVID-19 has impacted children and especially girls in unprecedented way. I was listening to the debates from the morning. I heard the Honorable Member of Parliament from South Africa raise issues around COVID-19 and model law, and it was raised again in the discussions and from the floor. I've just concluded 2 studies together with Plan International, I Am Swedish Development Partner, and a number of organizations in SADC and East Africa. We have a crisis in our hands. We have a crisis on the impact of COVID-19 on children, with lockdown measures, with unemployment, with schools dropouts, the high levels of teenage pregnancy, the high levels of child marriage. It's a crisis of a generation. And I think it really calls on the SADC Parliamentary Forum within your oversight committee to really build on the opportunities that you have to raise the issues, to provide the leadership and to provide the guidance. I know that as the role of Parliament is to legislate, oversight on budgets, represent us as a people, and to engage. And within those roles, my call would be for a very clear commitment, possibly to put as one of the indicators within your monitoring of the various model laws, a clear substantive work looking at COVID-19. I know there's been different recommendations that have been made, but definitely it might require a special session for us to look at the implications on COVID-19. Considering time, I will not dwell on the recommendations with regards to the legislative agenda that is before us, but just to say the African Union standards are clear. The age of 18 is the age of marriage with consent, because anything without consent, it's forced marriage. Even if the person is 22 years, it's forced marriage and should not be accepted and would amount to rape. I therefore recommend in terms of legislation that we continue to look at appropriate language within the SADC model law, the work that you do, because the word child marriage is a crime. It's rape. It's sexual exploitation, it's abuse. The more we continue to call it a marriage of a child, we continue to normalize, to sanitize, to rationalize on a gross form of abuse. So building on the work that you have on oversight for the SADC model law, we need a language that speaks to the heinous crime that is before us. Engaging with social norms and harmful practice is one of the most underlying and fundamental issues. I am very excited that within the SADC region are seeds for redefining and opening a new conversation around working with traditional leaders. I've seen the traditional leaders from Zambia, Malawi, Zimbabwe, and indeed we give our recognition to Chieftainess Kachindamoto of Malawi, launching model laws on ending child marriage. Really saying we need a new jurisprudence of customary law, which starts to align with our regional standards, like the SADC model law on ending child marriage, aligning with the international standards. I really want to appreciate Madam Secretary General for your presence at the recent event and session we hosted for the UN Commission on the Status of Women with the traditional leaders in SADC region who are starting to share on their experience. I therefore want to close with a few recommendations. My first recommendation is to request if the Oversight Committee could co-host a special session of yourself and the traditional leaders who are developing bylaws. What they are doing is to take the SADC model law on eradication of child marriage and placing it within the customary laws for which they have responsibilities. That would also in a way contribute to the legislative agenda, where our SADC member states would start not to use culture as a basis for having exceptionalism to the age of marriage. And I have heard that you have a forthcoming session in September. You may wish to create time to invite some of the traditional leaders working on bylaws to come and share their experiences, and for you to have an interaction as parliamentarians with the traditional leaders. I also recommend the issue around reporting. I know this was discussed in your October meeting as part of the oversight, that possibly you could consider the periodic reports at the regional level, even if it's to pick one indicator or two indicators from the SADC model law, which for that year you'd get data from the various countries and be able to track progress. And within that, I would equally encourage civil society to also do their shadow reports, their complementary reports, and that way we are able to bring both the evidence from the member states and also from the citizens. I remain so available as the AU Goodwill Ambassador, and also for the work I do with Rosaria Memorial Trust in my country, in Zimbabwe. My mother did not choose my father. At times I ask, am I a product of love or am I a product of biology? I know what she experienced. She talked about it. She talked about having a relationship for life and a sexual relationship with somebody you did not choose. We're talking about perpetual rape in a lifetime of a woman. We are not talking about a single incident of payment of lobola. We're talking about violence that perpetuates and the trauma that at times we don't talk about. And the children born of children who may never get a birth certificate, who will always be on the margins of society. We're talking about Africa and us as SADC reclaiming our own dignity. And you as the SADC Oversight Committee have been charged with the greatest responsibility, which I highly respect: accountability and monitoring of the expressed political will of our peoples on the continent to end child marriage within our generation. When we end child marriage, more girls are in school, more children are at less risk of HIV. We create democratic conversations at the household level. We are able to have our women and our girls on their bodies choose who to marry when. Indeed, it's a responsibility. We stand with you. I stand with you. I give you my full support. And again, congratulations. Thank you so much for inviting me and inviting us to this conversation. I thank you.
Thank you very much, Ms. Nyaradzai Gumbuzai, for your presentation. And you spoke passionately about eradication of child marriages and protecting our children who are already in marriages. And thank you for the recommendations that you have put forward. I'm sure the committee has noted your recommendations, and for sure it is very important for the committee to also work with all the stakeholders that are involved in working on the eradication of child marriages. Thank you so much once again, Ms. Nyaradzai Gumbuzai. Honorable members, I now call upon, okay, it's time for questions. When you're asking your questions or when you're making, you want a clarification, you should indicate who you are asking, is it Madam Eva or Madam Nyaradza, so that they can be picking the persons to give you responses. I open the floor for questions and seeking clarifications, honored members. Honored members, Madam Esti, can we also open it for other participants?
Indeed, Chair, at your pleasure. Thank you.
Thank you, Madam SG. We have also opened for our partners who have joined us in this meeting. If you have any questions, you can raise your hands. I'm not seeing any hands on my screen, or have I missed any?
There are no hands, Chair. Indeed, I've just checked the.
Okay. Thank you so much, honored members. We now come to the end of our meeting. Madam Esti, do you have any remarks before we adjourn?
No, Chair. Probably you could request Ms. Eva if she has any parting words from the comment of Angola, and we may
yeah, sure.
accordingly. Thank you.
Sure. Madam Eva.
Thank you, Esti. Thank you, Madam Chair.
On presentation. Okay, all right.
Yeah, I'm glad to hear what's happening in Angola, but I would still urge our member state to reconsider the age of 16. Those are children, and we are trying to get rid of age of 16 for any form of marriage. 18 is the minimum age that a child can get married, with or without consent. So I would very much urge them to reconsider the age of 16. I'm pleased about what's happening on birth registration, because that's a major obstacle to legislation being domesticated, because I've heard this being talked about, that how do we bring in a minimum age of marriage before we can set our birth registration systems. And most countries in Africa now are actually embarking on that reform, and we hope that they can finish soon so that we move ahead and not lose momentum on our model law being domesticated. Thank you, Madam Chair.
Thank you so much, Madam Eva, for that. Honorable members, with there being, we are not seeing any hands for questions and clarifications. I therefore, okay, Angola, you may come in.
Sim. Muito obrigada por me dar novamente a palavra. Queria agradecer à senhora Eva por esta sua recomendação relativamente aos casamentos de 16 anos. Farei chegar ao órgão competente para tratar disso, e pessoalmente também concordo consigo. De facto, 16 anos é uma criança, deve estar a estudar, mas há casos excepcionais em que crianças de 16 anos, mesmo na escola, aparecem em casa grávidas. E quando há esses casos aqui em Angola, as duas famílias põem-se de acordo para ver o que é melhor. a maior parte das vezes, os pais da menina, se ela estiver a estudar, preferem não fazer casamento. Deixar os dois crescer, fazerem os seus estudos e depois, mais tarde, eles resolverem. Mas, às vezes, noutros casos, as duas famílias põem-se de acordo e autorizam que se faça o casamento. E é só nessa base que o casamento é autorizado aos 16 anos, porque a idade prevista para o casamento é a partir dos 18 anos. Muito obrigada.
Thank you very much, Honorable Maria from Angola, for that explanation. Honorable members, there being no further business, the meeting is adjourned until next time. I thank you.
Thank you, Chairperson, for your able leadership.
Thank you, Madam SG.
Host, you may kindly terminate.
Thank you.
Thank you, Honorable Maria.
God.
See you soon.
Yes, thank you, Madagascar. Merci beaucoup.
Thank you.
Yes. Ronald, kindly take